it is some overwhelming majority with them. And in the organizational structure, and what
about the Rajya Sabha?
Lok Sabha
three Rajya Sabha are all with us.
and Lok Sabha.
Legislative, Lok Sabha, 6 are with us out of 19. Out of 18. So in 2 houses they have majority, in 2 houses we have majority. But be that as it may, this is the issue is ultimately not that. But just so that your lordship knows, in the organizational structure, the other surprising thing is, we both argued on the Constitution of 2018.
What is the organization?
On
What is the
Pratinidhi
structure of
Sabha,
organization of
there is a
Shiv Sena?
Pratinidhi Sabha and there is the Karyakarani, which is the executive, largest executive body, 13 members of the Karyakarani, and
General
about
bodies.
260 odd members of the Pratinidhi Sabha. Which will come to later. The point that I'm making is that we both relied upon the 2018 Constitution. But the Commission, in its order, without letting us know during the argument, said that the 2018 Constitution is not recorded in the Election Commission. Never put it to us, never told us, not their argument, not my argument. Both argued on the 2018 Constitution, and the Commission, without ever informing us, says that Constitution is not on our record. Anyway, but be that as it may. Anyway, so even though we have majority in the organization, they say we will not consider that. So they don't consider the organization, they consider this majority of those who are, according to us, disqualified, and give them the symbol. So you move from the Speaker to the Election Commission, and then from there, where do you go? Your Lordship sees the symbiotic relationship between the legislative party and the political party. The original political party, in relation to a member of a house, means the political party to which he belongs for the purposes of subparagraph 1 of paragraph 2. Paragraph means paragraph in this schedule. Then 2. Subject to the provisions of paragraphs 4 and 5, a member of a house belonging to any political party shall be disqualified from being a member of the house if he has voluntarily given up his membership of such political party, or if he votes or abstains from voting in such house contrary to any direction issued by the political party to which he belongs, or by any reason, or by any person or authority authorized by it in this behalf, without obtaining in either case the prior permission of such political party, person or authority, and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So, what's important here to note is that he cannot vote contrary to any direction issued by the political party. So, obviously, in terms of paragraph P, it's the political party which issues the direction, not the legislative party. And the direction is issued through the leader of the political party, normally the whip, or the leader of the political party. Such person authorized. So therefore the political party will authorize such person, and he is the whip. The whip term is not used in the 10th schedule, as you will notice. The term used is direction. Or by any person or authority authorized by this behalf, without obtaining in either case the prior permission of such political party. Normally, whose permission has to be obtained if I want to vote against the whip? Political party's permission. And political party is outside the house, not within the house. Within the house are only legislators. So you'll have to go to the whip, or the person authorized, look, I want to vote against, or I want to make a speech against. I don't agree with this bill. And sometimes, actually whips do agree. It has happened so often with us. You say, no, these particular clauses, I don't allow me to speak, but I will vote for you ultimately because I don't want to violate the whip, but allow me to speak. And sometimes we are allowed. Then subsection 2 is very important. An elected member of a house who has been elected as such otherwise than as a candidate set up by any political party shall be disqualified for being a member of the house if he joins any political party after such election. I belong to that category, Malad. So, Malad, if I try and join any other party, Malad, I shall be disqualified.
Anglo-Indians.
That's right. That's for nomination, not
3.
Yes. 3 is a nominated member shall be disqualified being a member of the House if he joins any political party after 6 months. That's what I told your lordships. From the date on which he takes his seat after complying with the requirements of 99. Notwithstanding anything contained in the foregoing provisions of this paragraph, a person who, on the commencement of the Constitution, is a member of a House, whether elected or nominated as such, shall, where he is a member of a political party immediately before such commencement, be deemed for the purposes of subparagraph 1 of this paragraph to have been elected as a member of such House as a candidate set up by such party. In any other case, be deemed to be elected. This we don't really worry about. Para 3 is now deleted, Malad. Now, Malad, let's see what para 3 said. The lordships will find that in statutes, Malad. Lordship has that?
Yes.
Yes. Got it?
Hello, Justice Shah has it. Now, disqualification on account of defection not to apply in case of split. Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. And such group consists of not less than 1/3 of the members of such legislature party, he shall not be disqualified under subparagraph 1 of paragraph 2. So paragraph 3 as it then stood operated on the assumption that there is a split in the original political party. A split in the legislative party would not have been a defense, even if it is more than 1/3.
There has to be a split in the original political party.
Now, how does that split happen? Because he makes a claim. Before all this happens, demonstrates in the claim that a split has occurred, calls for a meeting of the original political party, has a faction, has a resolution passed, breaks away, Malaj, and then if he is 1/3, it's a defense. Even if he loses, Malaj, in capturing the party, he shall not be disqualified under paragraph 2 that he is voluntarily, sorry, Malaj, where was I? Yes, that such group consists of not less than 1/3 of the members of such legislative party. He shall not be disqualified under subparagraph 1 of para 2 on the ground that he has voluntarily given up his membership of the original political party, or that he has voted or abstained from voting in such house contrary to any direction issued by such party, or by any reason or authority authorized by it in that behalf, without obtaining the prior permission of such party, person or authority, and such voting or abstention has not been condoned by such party, person or authority within 15 days from the date of which such voting or abstention. And from the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of 2, and to be his original political party for the purposes of that paragraph. So the splinter group of that party can be a separate political party. He will, because he is 1/3 in the legislature, belong to that party, because that becomes his original political party. None of this has happened here.
The quantum of the split, interestingly, was not defined in terms of numbers. So long as there is a split, the 1/3 is in relation to the group representing the legislative party.
Yes, yes, I agree, Madam. But that split may be minority, majority, it doesn't matter.
So long as, there is a split.
There is a split.
In the original political party.
Correct. So, that's not the case here, Madam. On 21st of June, they were in Gujarat and they were in the Northeast, only the legislative members. And they never said there's a split. They said, we are the Shiv Sena. So that claim was also not there.
Yes.
Now, let's kindly see this constitutional amendment. They amended 164 of the Constitution, which you will find, Malas, in PDF page 52. In article, I'm sorry, as Article 164 of the Constitution, after clause 1, the following clauses shall be inserted.
Where are we?
Well, is that PDF page 52?
PDF page 52, yes.
Well, this is the amendment starts, Madhaj, at PDF page
51.
51. And the relevant part, because 1A and 1B were added. And if you see section 3 of that, in Article 164 of the Constitution, after clause 1, the following clauses shall be inserted, namely 1A, the total number of ministers, including Chief Minister and the Council of Ministers in the state, shall not exceed 15% of the total number of members of the Legislative Assembly of that state, provided the number of ministers, including Chief Minister, shall not be less than 12. Provided further that the total, we are not concerned with that. 1B, Malas. A member of the Legislative Assembly of a state or either house of the legislature of a state having legislative council belonging to any political party who is disqualified for being a minister of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire, or where he contests any election to the Legislative Assembly of a state or either house of the legislature of a state having legislative council, as the case may be, before the expiry of such period till the date on which he is declared elected, whichever is earlier. This also creates a lot of problems. That problem doesn't confront us in this case, because most of these people then resign, join the other party, get elected, become minister. So there is some scope for challenge to this particular provision, its constitutionality. But be that as may, we are concerned with the earlier part.